Your UK will is a ticking time bomb in Spain. Let's be direct. Relying solely on your UK will to handle your Spanish assets is one of the most expensive mistakes you can make as an expat. It feels logical. You have a will, it covers everything. But the Spanish legal system does not see it that way. When your loved ones present a UK will to a Spanish notary, they aren't met with a simple process. Instead, they kickstart a bureaucratic nightmare that can last over a year and cost them upwards of €10,000 before they see a single cent of their inheritance. The will must be sent to the UK for a grant of probate, then returned to Spain. It needs an official Hague apostille to be legally recognised, and then every single page must be translated by a court-appointed sworn translator, a traductor jurado. Each of these steps adds months of delay and thousands in fees. This isn't a minor inconven, i.e., it's a significant financial and emotional burden placed on your grieving family at the worst possible time. The entire process freezes your Spanish assets, including bank accounts and property, leaving your heirs unable to manage or sell them. The fundamental issue is jurisdiction. A Spanish will is designed for one purpose: to efficiently distribute your assets located in Spain. A UK will is designed for UK assets. While it can technically cover worldwide assets, forcing it through the Spanish system is like trying to fit a square peg in a round hole. The gold standard and the universal advice from any competent lawyer in Spain is to have two separate compatible wills, one in the UK for your UK assets, and one in Spain, signed before a Spanish notary for your Spanish assets. This Spanish will should explicitly state that it only applies to your assets in Spain, ensuring it doesn't accidentally revoke your UK will. The process is straightforward. By creating a Spanish will, you are creating a document that the local system is built to handle. Your heirs can walk into a notary's office with this document and the death certificate, and the process can begin immediately. There's no need for the grant of probate from a UK court, no need for the expensive apostille, and no need for a sworn translation. It simplifies the entire affair from a complex international legal challenge into a manageable administrative task. One of the most jarring differences for anyone from the UK is the Spanish concept of legítima, or forced heirship. In the UK, you have testamentary freedom. You can leave your assets to whomever you wish. In Spain, the law protects certain heirs, primarily your children. By default, Spanish law reserves 2/3 of your estate for your children. This is non-negotiable under Spanish civil code. Let's break it down with an example. Imagine your Spanish estate is worth €600,000. The law divides it into 3 equal parts of €200,000 each. The first third, the Legítima Estricta, must be divided equally among all your children. The second third, the Mejora, must also go to your children, but you can decide how to split it, perhaps giving more to one child than another. Only the final third, the Libre Disposición, is yours to leave to whomever you choose, whether that's a spouse, a friend, or a charity. This means you cannot disinherit a child, and you cannot leave everything to your surviving spouse by default. For many UK expats, this is a complete shock and goes against all their estate planning intentions. Now, after hearing about forced heirship, you might be concerned, but there is a critical solution. It's called the EU Succession Regulation, more commonly known as Brussels IV. This regulation allows you to formally elect for the law of your nationality to apply to the succession of your estate. As a UK national, this means you can include a specific clause in your Spanish will, stating that you choose the law of England and Wales, or Scotland, or Northern Ireland, to govern your inheritance. By making this election, you completely bypass Spanish forced heirship rules. You reclaim your testamentary freedom, allowing you to distribute your Spanish assets exactly as you wish, just as you would in the UK. This is arguably the single most important clause to include in your Spanish will. Without it, Spanish law applies by default. A good bilingual lawyer, an abogado, will ensure this clause is included and worded correctly. It is a simple, powerful tool that puts control of your estate firmly back in your hands, ensuring your final wishes are respected without being overridden by local inheritance laws that were not designed with your circumstances in mind. The process after death, known as probate, is vastly different and highlights why a Spanish will is so much more efficient here. In Spain, a will signed before a notary is a public, legally binding document from the moment it is created. The notary registers its existence with a central registry in Madrid, the Registro General de Actos de Última Voluntad. When you pass away, your heirs simply obtain a special certificate from this registry, which confirms the existence of the will and names the notary who holds the original. They can then go directly to that notary to get a certified copy and execute the will. It's an administrative process, not a judicial one. Contrast this with the UK. A UK will must go through a formal court process to obtain a grant of probate. This grant is the court's official recognition that the will is valid. This process alone can take 6 to 9 months. Only after the grant of probate is issued can the will even begin the process of being legalized and translated for use in Spain. The Spanish system, by treating the will as a public document from day one, removes this entire court-based bottleneck. Another fundamental shift in perspective involves inheritance tax. In the UK, inheritance tax, or IHT, is paid by the estate. The executor calculates the total value of the estate, subtracts liability, i.e. and allowances, and pays the tax bill to HMRC from the estate's funds. Only after the tax is settled are the remaining assets distributed to the beneficiaries. Spain turns this entire concept on its head. Here, the inheritance tax, the Impuesto de Sucesiones y Donaciones, is paid by each individual beneficiary. The estate itself pays nothing. Each heir is responsible for filing their own tax declaration based on the value of the assets they personally receive. The tax rate and allowances depend heavily on 2 factors: the beneficiary's relationship to the deceased and the autonomous community where the assets are located. For example, here in Andalusia, the allowances for spouses and children are very generous, currently up to €1 million per beneficiary tax-free. However, the declaration must still be filed within 6 months of the date of death. This is a hard deadline that can be difficult to meet if you are stuck waiting for a UK grant of probate. Let's make this real with a story of 2 neighbours in Meahaz, John and Jane, who both passed away, leaving a €200,000 apartment to their 2 children. John only had a UK will. His children had to hire lawyers in both the UK and Spain. It took 7 months to get the UK grant of probate. Then another 2 months for the apostille and sworn translation, costing them over €2,000. All told, it took 18 months before they could even register the property in their names, with total legal and administrative fees approaching €12,000. Now, consider Jane. She had a Spanish will for her apartment. Her children took her death certificate to a Spanish lawyer. Within 3 months, they had signed the deed of acceptance and adjudication of the inheritance at the notary. The total cost for the notary, registry, and legal assistance was around €4,000. They were able to sell the apartment within 6 months. The difference is stark: 18 months of stress and €12,000 in costs for John's family, versus 3 months of smooth administration and €4,000 in costs for Jane's. This is the practical, real-world impact of having the right document in the right country. So, what is your immediate action plan? First, accept that if you own property or have significant assets in Spain, you need a Spanish will. Second, find a reputable, bilingual Spanish lawyer, or abogado, who specializes in succession planning for expats. Do not simply go to a translator or a gestor for this. You need proper legal advice. Third, instruct your lawyer to draft a Spanish will that deals exclusively with your Spanish assets. Fourth, and most importantly, ensure they include the Brussels IV clause, electing for UK law to govern your inheritance. This protects your freedom to decide who gets your property. The entire process is simple. You will have a meeting with the lawyer, they will draft the will, and then you will sign it in person before a Spanish notary. The cost is surprisingly low, typically between €300 and €600 for a straightforward will for a couple. This small, one-time investment provides enormous peace of mind and saves your family a fortune in time, stress, and money. It is the responsible and correct way to manage your affairs as an expat property owner in Spain.